Hello, everyone, and welcome to this Logical webinar. I'm your host, Casey Sullivan of Logical.com. Today, we're going to be addressing ransomware and the future of law firm cybersecurity, a topic that couldn't be more pressing. As you may know, this summer alone, we've seen a massive worldwide ransomware attack on multiple occasions, including one that shuttered one of the nation's largest law firms. But ransomware isn't just an issue that impacts large firms or large businesses. Indeed, any business of any size and any law firm of any size can be impacted. As we'll learn, they already are. So with that, let's look at our agenda. We're going to start today talking about the cyber threat landscape and doing a quick survey over cyber attacks in the last 2 years. We'll move on to discussing the consequences of a successful cyber attack, which I'm sure you can assume are often devastating. We'll look at the role that cyber insurance can play as a potential prophylactic against attacks, or in some cases, not one. And finally, we'll end with what everyone desperately wants to know, which is how to go about protecting yourself and your law firm. We are excited to have two great presenters with us today. Brian C. Folk is an attorney with Stiles, Byram, and Horn in Charlotte, North Carolina. And as of August 1st, we'll be launching his own law firm, the Law Offices of Brian C. Folk. He is also the man behind The Cyber Advocate, a well-respected blog on the application of new technology to the practice of law. We're also very excited to have Olga V. Mack with us today. Olga is a startup lawyer who currently serves as general counsel at Clearside. She's previously worked for Zeus, Visa, Pacific Art League of Palo Alto, and Wilson Sonsini, Goodrich, and Rosati. In addition to regularly speaking and writing on cybersecurity and related issues, Olga is a passionate advocate for women and the founder of womenserveonboards.com. That's womenserveonboards.com. We want this we want this presentation to be as interactive as possible. So if you have any questions, please go ahead and enter them into the question box on your GoToWebinar app, and we will pass those along. We'll dive in. Starting by surveying the cyber threat landscape, I'll begin before passing the baton over to Brian. So we'll start here with a quote from Eli Wald, who is an ethics professor and a former big law attorney. From the perspective of hackers, exactly because lawyers handle such valuable and sensitive information belonging to clients, law firms become a one-stop shop, which was especially true in 2016, what we're calling the year of the legal data breach. So Brian, do you want to take us through that?
Hacks that we saw the, on the law firm side, you have the Panama Papers, where one of the largest international law firms that apparently was the ideal place to set up entities and trusts to launder money was hacked by several agencies and then had their information distributed to, I think, 25 to 30 different newspapers who broke it. Der Spiegel was one of the leading ones. There have been a number of law firm breaches, but really when you're looking at the overall landscape of what dangers lurk out there, the idea of pointing to any one breach at any one time really kind of misses the whole point. And there's a reason for it. It's because the old idea of the one hacker seeking the information from one person is a flawed idea of the biggest threat that most of us really face. And the reason is because that threat is ransomware. If 2016 was the year of the hack, 2017 would be the year of ransomware, or at least we'll call it ransomware's coming out party. Ransomware is malware that blocks you from accessing your stuff. It can do it in a wide variety of ways. In fact, I've seen some that are truly terrifying, but the most common one is it encrypts your files. It encrypts the most important files for you to use: documents, PDFs, Excel spreadsheets, PowerPoints, images, various things like that. Although what's funny is most ransomware doesn't actually encrypt already encrypted information. So you could avoid an issue with that way. But ransomware is different from the normal threat model because the imperfect analogy I like to use is if one hacker going after one target is a guy sitting on a dock fishing, ransomware is that hacker going on a boat, taking a giant net and dropping it in the water. Ransomware is not seeking your data. Ransomware is not seeking your address book for the most part. Ransomware doesn't care who you are, where you are. Ransomware wants a small amount of money. It is a huge threat because of its pervasive quality and because, for the most part, most ransomware actors have fallen in a unique sweet spot. The FBI isn't interested because each individual action isn't big enough. It would technically be across state lines and everything like that. The FBI definitely has jurisdiction, but the deputy director of the FBI responsible for cybersecurity in 2015 said that his best advice when confronted with ransomware was to pay it. But 2017 has seen a couple of interesting things. First and foremost was the WannaCry attack. In May, helpfully on the morning where I woke up in Germany, this screen showed on more than 200,000 systems worldwide. The WannaCry ransomware attack, it was as big of a ransomware attack as we've ever seen. And interestingly enough, as far as ransomware goes, as ineffective as a ransomware attack can be. "150 countries, and it exploited very specific flaws." Now, the NSA and the CIA have a whole lot of responsibility for the big attacks that have come this year, but it's why they have responsibility that makes it interesting to look at. It exploited an old flaw in Windows XP, actually. If you had updated your computer 30 days before this attack hit, you were fine. It demanded a much higher Bitcoin payment than you usually see. And it hit some really big entities. Probably the most consequential was locking out the Britain's National Health Service. The German train service that I had to rely on that particular morning was also affected. Fortunately, Germany being more of a cash-based society than we are, I was able to simply use cash, but I couldn't use a credit card and I needed to get to an airport to make a transatlantic flight. Not fun. Interestingly though, WannaCry was a failure. It was stopped and very little money was collected. And part of the reason was because, just like what we're talking about next, it wasn't exactly ransomware. In late June, this screen came up in computers all over Europe. This has been referred to as Petya, or I actually call it the not Petya, because Petya was a version of ransomware that was released in 2016, has a lot of different versions, affects a lot of different people, and its base language and coding system is what the not Petya attack used. It also used a similar flaw as WannaCry that was released from one of the NSA's hacking tools, something they had for years but didn't tell anybody about. You can jump ahead. There you go. Now, no, not that. So here's what was interesting about the WannaCry and NotPetya attack. Now, NotPetya hit Merck, Heritage Valley Hospitals in Pennsylvania, Cadbury's, and what horrible person would want to lock up a chocolate company, and interestingly, DLA Piper. We'll talk about them in just a minute. But I want to discuss this interesting concept. It is the year of ransomware, but also the year of not, because both WannaCry and NotPetya are essentially believed to be fake ransomware attacks. Most experts now attribute WannaCry to the North Korean government, and it is strongly believed that one of the reasons that they launched it was to distract attention from one of their missile tests. The NotPetya attack, also not true ransomware. In fact, it couldn't be effective ransomware. It was not designed to hold files for ransom. It was actually designed to destroy them. It is believed to have been launched by the Russian government as part of its massive cyber attack against Ukraine. Ukrainian government systems were the biggest ones hit, and as a pretty good reason of why you don't release a biological pathogen into the air, the country second most affected by the virus once it got let loose into the wild was Russia. Now, I want to move on to talk about DLA Piper specifically. When DLA Piper was hit on June 27th, the attack started in Madrid. It then spread via their VPN system and shut down their email, phone, and computer systems. It essentially shut down completely 5 of their offices in Europe and affected most of their offices worldwide. Their employees were told not to turn on any computers that were turned off. They couldn't plug into anything. They couldn't access anything. Now imagine that you're a part of a global network and you're unable to even look at your files. That's what the lawyers at DLA Piper were dealing with. The threat is real, and the damages that you can incur from those threats are real. And among the biggest ones that you will see, people always fear being sued from outside, but in reality, the largest damage that you're going to incur from a ransomware attack is lost productivity. It's what you can't do while you're standing there waiting for someone to decrypt your files. There's also lost billable hours. There's also potential litigation, and that will all be discussed in greater detail and sort of how you can address these problems. But there's actually one interesting case going on right now in Rhode Island that I want to talk about. Now, on a very basic level, I want to introduce that I'm a cyber liability and cybersecurity lawyer, but I also have extensive experience in insurance coverage issues. So there's this law firm in Rhode Island, Moses Alfonso Ryan, and they got hit with ransomware. So they tried a bunch of things and they ended up suing their insurance company, and they're suing now for $700,000. Just the complaint itself is actually a pretty solid demonstration of how not to A, prepare for a cyber attack, B, respond to a cyber attack, and C, completely fail to read the terms of your insurance policy. Specifically, I want to turn to this one averment in their complaint, and forgive me, I'm going to read it because it is there's a lot of interesting things to unpack in this one paragraph. Unfortunately for MAR, it took over 3 months to 1, identify the perpetrators of the ransomware attack, 2, contact the perpetrators of the ransomware attack, 3, negotiate a ransom, 4, obtain payment in form of Bitcoin, 5, obtain the initial decryption tools, 6, attempt to use those tools, 7, discover that those tools didn't work, 8, reestablish contact with the hackers, 9, renegotiate an additional ransom, 10, obtain additional payment, 11, obtain the second set of decryption tools, 12, recover the documents and information encrypted, 13, recover or recreate documents that were not saved during the 3 months of business interruption. There are so many things that are wrong here that it's disturbing. And I'm not talking about the fact that there was ransomware or that the hackers didn't produce the key on the first time. That's pretty common. The response of Moses Alfonso to this attack is pretty much a how to not effectively respond to an attack. Interestingly, they brought in their own experts, and their own experts tried to break into the encrypted files, but they couldn't. So for some reason, apparently adequate backups were not available. They had to go on their own backup system for 3 months. And so for 3 months, they were creating documents, creating files, to serve as stand-ins. And then as soon as they recovered their primary files, they lost their backups. The complaint itself, when read from start to finish, really is an interesting comedy of errors in how this was handled. I hope that everyone listening read that first part and said they had to spend time locating and then attempting to contact the people who were holding them hostage. It's a pretty poor hostage taker who doesn't make himself easy to contact. There's a lot of weird things like that in this complaint, but here's one that to me is probably the most bizarre. It says that the policy that they're suing over contains a loss of business income policy. It says that the insurance company, quote, will pay for the actual loss of business income you sustained due to the necessary suspension of your operations during the period of restoration. The suspension must be caused by direct physical loss of or physical damage to property at the scheduled premises, including personal property in the open, end quote. If you've ever practiced in North Carolina insurance defense, which is what I have done a lot of, this complaint is dismissed based on that paragraph. I'm going to spend the rest of my brief time here talking to you about what it really means to have insurance coverage for hacks. Cyber liability insurance is new. Now, whether you have it as a version of your current policy, which is what the law from the previous example had, or if you have your own policy, you probably need some version of it. It's going to protect you against viruses, it's going to protect you against loss of computer and digital assets. Your current insurance might have it, but I promise you that in 5 years, it won't. Most insurance companies are running for the exits when it comes to a policy that is a CGL policy that also includes cyber liability. They don't want to have anything to do with it as a small section of one policy. It's going to be standalone. So what are you looking for? Well, you've got to know what your policy covers. Like the lawyers in the law firm absolutely did not. They had no frigging clue that the business interruption section of their policy requires physical loss. In fact, the insurance company that they had paid them $30,000 under their computer addendum of their policy. So you've got to know what's in your own policy. Does it emphasize first party versus third party? Well, what does that mean? And before I go any further, there is one point that I want to make that is absolutely crucial when it comes to cyber liability insurance. Forget everything you know about how insurance policies in this country tend to operate, because all of those insurance policies have been around for a long time. From company to company, the policies that cover the same stuff have very little in terms of differences when it comes to material terms. In fact, most of them are identical. That is exactly the opposite of the case of cyber liability insurance. It's new. No one really knows exactly what to put in it. And so no cyber liability policies contain the same things. So you have to know first party versus third party. Well, your first party coverage protects you against things that you might experience. Some costs include forensic investigation, legal advice, notification costs, offering credit monitoring, PR expenses, and lost profits. Third-party expenses include defending yourselves against lawsuits and regulatory action. Do not forget that. One of the most important things your insurance policy will protect you against is the regulators that come and ask, well, why didn't you protect your stuff better? Settlements and damages, liabilities to banks, cost of responding to regulatory inquiries, and fines. Emergency and expert services. Guess what's going to happen when you get hacked? Well, first, don't do like the Moses Law Firm did. Call your insurance company immediately, because the first thing they'll do is they'll call their experts. Any insurance company that offers cyber liability insurance has a short list of IT companies that are going to, basically their job is to airdrop in and fix your stuff as fast as possible. You're also going to need breach response management. My personal advice to any small business is to retain cybersecurity counsel before an attack hits. But regardless, you're going to need it afterwards. Usually that's legal advice. You're also, believe it or not, going to need PR advice, because guess what? Your reputation doesn't really get better when the public finds out that you were hacked. It might not get worse, but it doesn't get better. The next thing you're going to need is notification expenses. Most insurance companies have contracts with companies that have call centers set up and staffed, ready to go, to notify people either by letter, by phone, or by email of the attack. Data restoration expenses. Well, you've lost your data. Are you going to get anything for building it back? Most policies are going to have exclusions for software that you did not own. So anyone who downloads a lot on BitTorrent is probably not going to be doing too effectively with these policies, but you're going to have costs incurred when you restore your systems. Does your insurance policy cover it? And then the most important, business interruption. What Moses has either discovered or is about to discover is that business interruption is not only huge, but not really covered by a minor portion of a policy. You need effective business interruption coverage for cybersecurity policies to be truly effective, because that is going to be your biggest loss. When picking a policy, and like I said, forget everything you know about policies, because they're all different. And when talking to a broker about cyber liability insurance, Make sure your broker is experienced in cybersecurity if you're relying on their information. I got a secret for you. All of the brokers that I've spoken to, only one, who happens to be a former FBI agent specializing in cybersecurity, had any idea of what his policies actually covered. So bring a friend, or as I actually say more clearly in one of my blog posts for Logical, bring a cybersecurity lawyer who is experienced in insurance coverage. They need to know the language of insurance and the language of cybersecurity. You want to know, is this simply going to be a rider on a CGL policy, which means you're only going to have small policy limits, limited coverage options, or is it its own individual policy? Does your policy have a duty to defend versus a duty to reimburse? Well, what is that? Well, if you want to be able to pick your own attorney, you better have a duty to reimburse. Duty to defend says they get to pick your lawyers. It may be explicit, it may not, but it's a very key difference. Responsibility for expenses. Might seem strange, the idea that the expenses wouldn't be covered by your insurance, but various secondary or ancillary expenses, including additional new technology, software to help repair your breach, replacing existing servers that may have burned out as a result of a hack, any additional experts, any additional fines may not be covered by certain policies. Sublimits and exclusions. Well, let's say you have a $100,000 cyber liability policy, but a $10,000 attorney fee sublimit. Let's hope you don't need that attorney for more than $10,000 worth of coverage. What exclusions does it include? Did you know that most cyber liability policies exclude hacks based on intrusions from laptops if you've lost your laptop and didn't report it fast enough? What about prior acts? You have to know whether or not your cyber liability policy is going to cover a hack that began prior to its term. Most hacks take a while. Criminal acts by an employee may also be precluded, but the biggest one is you could actually lose coverage based on a simply failing to protect your stuff. Do you have policies that you didn't follow? If so, you may be out of luck. What isn't covered? Well, most insurance policies don't cover loss to reputation. It's pretty hard to monetize, but they also don't cover loss to future business. And most importantly, every single state law requires you to read your insurance policy, and you are charged with the knowledge of the contents. Anything that's not in the policy is not covered, as Moses is finding out now. What does your policy cover? And with that, I will turn the presentation over to Olga.
Great, thank you so much, Brian. We have a quick question from the audience. Do you expect more litigation like the Moses Alonso suit in the future?
I do, but in a different way. I think the big thing that you're going to see is not whether or not these policies cover it, because most states have insurance law that's very clear. If the language of the policy is not ambiguous, then the language takes on its normal meaning. And the normal meaning of this policy, you can actually read it for yourself in the complaint. They included all the language that clearly state that they're not entitled to recovery. I mean, in my opinion, this case is a quick 12b6. The big issue for me, I think, coming up when it comes to insurance is covering, or is litigation based on exclusions. Whether or not a company, or rather just an insured, has adequately complied with all the terms of the policy. Now, one of the big ways you can reduce the cost of cyber liability insurance is by voluntarily adopting security measures, password policy, third-party vendor policies, making sure you have a good physical security policy, allowing audits of your system, pen testing, all that. By doing that, you can actually get your insurance company to lower their premiums, but you are also obligating yourself to have those things in place. And if after an attack, an audit discovers that you weren't actually enforcing your obligations, you may find that you're excluded from coverage. That is actually where I expect most of the litigation to focus on.
Okay, great, thank you. And that's a perfect transition over to Olga Mack's presentation on the steps that you can take to protect your law firm. So we'll hand it over to you, Olga.
Thank you, Brian, and good afternoon, everyone. Brian, I completely agree with you that, well, first of all, thank you for your insight about insurance. Haven't had dealt with insurance before, I can tell you that it is complicated in all possible stages, from procuring to negotiating to litigating. And I completely agree that having a friend, and better yet, an outside attorney who both fluent in cybersecurity and insurance on your side is probably the best decision I've ever made for myself when negotiating cyber coverage. At this point, we have had numerous attacks on a number of law firms, and by this time, most in-house attorneys have realized that law firms are excellent targets for all kinds of attacks, from ransomware to just about any other kind. They sit on valuable information such as financial data, corporate strategies, trade secrets, business transaction, PII, PHI, you name it. So they're absolutely amazing targets. They also often lack effective privacy and security programs to protect that information. So, for example, recently, 22% of law firms in ALM legal study indicated there was no organized plan in place to prepare or respond to a data breach. The same study has found that only half of those law firms have included in the study have cybersecurity teams in place to handle complex programs that are needed. So, yes, when we talk about cyber attacks on law firms, I think it's very important to realize and remember that law firms are first and foremost victims. And while there are definitely plenty of things that law firms and any law provider, and frankly any vendor, can do to decrease the odds of attack, information loss, and decrease of uptime, I think it's very important that we should not blame the victim, and then more importantly, in-house counsel, law firms, alternative law providers, offshore solutions should work together to address cybersecurity. We are in this together, and we are also dealing with what appears to be state-sponsored bad actors. And so we should, on some level, stop pointing fingers at law firms and providers and really figure out how we're going to solve this problem together. So to that end, I think we should absolutely stop approaching cyber conversations in the same awkward way that we have approached high school conversations about prom. I think it's time for companies and law providers and law firms to have systematic adult conversations about cybersecurity. Next slide, please. So let me discuss some of the sample of conversations that I think law firms should expect and companies should be prepared to have. Many companies at this time have onboarding experience for majority of their vendors, and law firms are no exception. They're just another vendor that happens to have a lot of sensitive information. So some of the basic questions to ask, for example, does your law firm have use two-factor authentication for all services and apps that house sensitive data? It is well known that having a two-factor authentication helps combat many attempts and attacks. Another question to ask is, how often do you update your operating systems? And more importantly, how do you force everybody in your organization to update them in a timely manner? Because as we know, installing updates is annoying. They take time, they take billable hours away. It's quite annoying to stare at the screen, but as the computer uploads various patches and updates. On the other hand, not doing them in a timely manner really exposes the company, the organization to attack. So the real question is not only do the updates happen, but does everyone participate in them? Another question to ask is what is encrypted and how and where it all lives. It is relatively simple to encrypt disks. And when a company onboards a law firm, it is very important to have an adult conversation about what is very important, what has to be protected, and how, and divide data and information in various piles and buckets to make sure that it is properly handled. Another conversation worth having is how do you approach passwords? Simple things like passwords are very important. Human mind is relatively limited in how many random passwords it can hold in its mind. Password managers, on the other hand, are much more effective in helping generate strong passwords and manage credentials for multiple accounts. And they do not require you to remember them all. You can only remember just one. So it is important to ask what is the overall approach for any law provider or a vendor toward password management. I find it very enlightening to talk to vendors, including law firms, about how they handle training, because how often, how regularly, and whether or not they include third parties, and whether they actually run through real life exercise highly correlates with whether or not they take cybersecurity seriously, and whether or not they have a mature approach towards cybersecurity. So it is worth asking about the details of the employee training and how they make sure that everybody, from paralegals to the most senior partner, is trained on basic principles. Having been in a number of insurance discussions, I completely agree with Brian that not only do you have to, you absolutely have to forget everything you know about insurance, but I also will add to that you have to forget everything you know about drafting legal principles and, frankly, English language, because having gone through various paragraphs of my and others' insurance coverage, I have quickly discovered that the interpretation is nothing that I would expect. And so having somebody who has seen and negotiated and has been through numerous stages and different stages of insurance on your side is very important. I think it's a good idea to include a friend, so to speak, when you negotiate endorsements and amendments to your insurance policy. It is also important to understand what it is you bought and where it leaves, because sometimes cybersecurity pieces do not leave in the same place. They may be living under different pieces and places in your umbrella coverage. And then, of course, if you happen to be in litigation, you will obviously get a friend there. But I think it's very important to have an insurance friend in all stages of that of insurance life cycle. A meaningful discussion on disaster recovery plan is also a good idea, because as Brian and logical folks have alluded, interruptions can be costly. They're costly in terms of business, they're costly in terms of reputation, they're costly in many ways. And so understanding, does the firm have a disaster recovery plan? How does it work? Do they actually have drills? Have they actually had to ever use it? All of those questions are important to ask. There are numerous other questions that you could be asking, from physical security to training efforts to regular risk assessment, regular backups, and many, many other questions. You'll find that nobody has everything, because the bottom line, compliance is very expensive, and we all have to make business decisions what makes sense. So what is important to have is conversation and understand what your vendor has and what your vendor doesn't have, and how does your vendor mitigate the risk that he has. And being informed about it is the first step toward managing those risks. I will leave you with one last final thought. having an intentional and systematic security approach is not just a nice to have item. It is an absolute competitive advantage for anybody who frankly is in business, and definitely who provides legal advice. So it is absolutely important to take a step back and look at the system you have, look at the practices you have, evaluate what you have, and add pieces that are missing over time or as quickly as you can. And then explain them to your clients and explain and update them regularly how their information is treated. And then if the attack happens, have a systematic approach in handling the attack. All of this requires an intentional and systematic approach as opposed to ad hoc. And increasingly, given how many attacks we've had, it is becoming a competitive advantage for law firms to have that in place.
Great, thank you so much, Olga. We are now going to open it up to questions and provide some answers for you. You can put your questions in the questions box on the GoToWebinar control panel, and those will be sent over to us and we will relay them. We'll start with a question for you, Olga. When you go through these conversations with your outside law firms, do you ever get any pushback? Do firms resent being treated like vendors, or are they mostly receptive to the questions and issues you're raising?
You know, the firms are not necessarily thrilled, but the way discussions I've had in numerous organizations is that I will start a discussion. In my current organization, in my prior organizations, I've had somebody who is actually a head of privacy and security, and I will explain that the process for me to onboard and to sign the agreement requires every vendor, including a law firm, to go through the process, and I will connect them with my cybersecurity counterpart, and we have a process and questions in place, and he often does calls, and I am often on those calls with some vendors, especially if they're on the legal side, and I explained that the process we have at my company is that for us to onboard any vendor and ultimately write a check for the vendor services, we absolutely require to go through privacy security discussion and filling out some papers and some disclosures and explanation of what systems are in place. So I think I would get less of a pushback now, because I think it's becoming increasingly a norm, especially in light of numerous attacks. I've had more pushback on that in the past. But I think, as I said, I think it will be increasingly difficult for law firms to say no to the proposition of explaining its security and privacy efforts.
Great, thanks. And we have a question for you, Brian. This is actually, I overlooked this before, but one of our audience members wants to know if a bad faith claim against your insurer will impact the insurance company's right to choose the lawyer who defends you.
Well, your bad faith claim, I mean, that's saying a bad faith claim against an insurer is an incredibly broad discussion. What area of bad faith are you referring to? You know, when did the bad faith occur? Are you talking about a piece in the past? I would argue that your policy is going to be interpreted by the terms of the policy itself. I don't think that you're going to run into too many policies that are going to allow you to use the attorneys that it's paying for to sue the insurance company. However, I think that there's probably an argument to be made that, and I've not actually seen one of these won or lost, because this is actually not a scenario that I've dealt with, but I would imagine there's an argument to be made in any case that if your insurance company is being accused of bad faith, that you should be allowed at least to choose I don't know about comparably priced, but a comparable level of representation. And I can't see too many insurance companies fighting that, if for no other reason than it would simply add considerably to the likelihood that a jury would find that they had committed bad faith.
Great. We have another question for you, Brian. Is it better to have a robust cyber liability insurance policy or a contract with an incident response company?
There are two entirely different things. A contract with an incident response company is essentially like basically all it really means is you have retained emergency IT. That is very narrow. A cyber liability insurance policy, in my opinion, is actually good for not just the things that it provides in the bad times, but for the things that it makes you do in the good times. They will lower your prices considerably in order, if you follow better security policies. Most lawyers, in my experience, may not have any idea about why. They may hate their password policy, but every month when they look at those insurance premium checks, if they see a considerable drop, you bet they're going to use one, especially the smaller the firm you get. More importantly, the insurance policy is going to cover more than just the IT company that comes in and helps you fix your stuff. They're going to pay for the person who does the response management, most likely. They're also going to, most of them offer PR help, which do not underestimate, especially for reputation-based industries like professionals practicing law, how important it is to get out in front of any news story about your firm being hacked. Beyond that, you're also going to want continuing legal help. One of the reasons why I actually recommend having a retained cybersecurity counsel, not necessarily retained IT, is because the retained cybersecurity counsel can do things like identify the regulators who have jurisdiction over your business, and in establishing personal relationships with them, know exactly what they're looking for when they get there. Because for most hacks, the biggest difference in how a regulator views the performance of the company that's been hacked is based entirely upon the first hour that they spend at the company after they've been notified. Because it's the difference of whether the attack manager has everything that regulator wants to look at ready to go, all compiled, and is just ready for them to go. If the regulator gets to the office and everyone's running around with their hair on fire, that's probably your first indication that the regulator's not going to issue a positive finding. But insurance policies provide so much more than just IT help. That's why I say they are entirely different.
Great, and we actually have your popular man today. We have another question for you. This is in regards to the discovery phase of litigation. So an audience member asks if you've seen requirements in litigation confidentiality agreements between parties during discovery that would require all parties to have a cybersecurity protection or specific cybersecurity measures.
Yes, and in very short order, it's going to be all of them. If you use e-discovery at all right now, it's one of the biggest areas of e-discovery law. Currently, this is what it was 2-3 years ago. People were talking about how law firms may be the soft underbelly of corporate cybersecurity, but the e-discovery companies are holding all of the data, oftentimes even more data than the judge is going to allow the other side to see, on the litigants involved. So they become incredible targets. So any major company or big law firm that uses e-discovery regularly has built into those e-discovery contracts very stringent cybersecurity measures. You're going to see it more and more, and especially in personal injury practice where medical records are available. I think you're gonna start seeing it being taken a lot more seriously.
Great, and with that, we are gonna stop questions. Thanks everyone for joining us. Before we wrap up, I know we're a few minutes early. Here is the contact information of both of our presenters. That's Brian Folk at folklawfirm.com, and you can follow him on Twitter at @NCCyberAdvocate, Olga V. Mack at helloolgamack.com. And you can also follow her on Twitter at Olga V. Mack. If you want any more resources, we have plenty for you. So this is a listing of several things that Logical offers. We have a white paper on using the cloud to secure your practice. If you are on budgetary constraints, oftentimes going to the cloud can be the fastest, the easiest, and the least expensive way to ensure that you have someone who's fully devoted to your security in charge of your most important data.
We also have a guide to how technology is reshaping e-discovery. As Brian mentioned, e-discovery is where we collect all of our most valuable information, and it has become a major target. So this will help elucidate the ways that technology is changing that process and help hopefully making it a bit more protected. We also have a white paper on safeguarding client data, and of course you can see a demo of Logical, which is a powerful and simple but highly secure e-discovery and data management software. Finally, a plug for Closing the Loop, which is the blog I write for Logical. It has daily updates on e-discovery, cybersecurity, and other news. We have interviews with judges and practitioners, including a new interview with U.S. Magistrate Judge Waxy that just went live this week. So you can sign up for it or check it out at blog.logical.com. Thanks again, everyone, for joining us. We will send out the deck and a recording of the presentation via email in a day or two, and have a great rest of your day.